as an officer of the court, and you don't see much of this kind of drama, is it? That, you know?
Not really. I've personally not witnessed something of this sort before. So it's quite strange to see a lawyer in the middle of proceedings seek leave and walk away simply because they disagree with the court. So this is quite strange for me personally. I haven't seen one play out in court before. But what is the context? The context is that the learned attaché had a pending application before the Supreme Court. And that application was in respect of matters in the ongoing trial.
Right.
So recall the last adjourned date, prosecution put in the box their second witness.
Yes.
What that meant was that they were to lead evidence. And it's at that stage that defense can raise objections to the tendering of certain evidence. So it was the contention of defense that certain documents that prosecution were going to tender in evidence were prejudicial, and to some extent they will compromise national security. That was opposed. So it was an argument for which the court had to decide. The court decided in favor of prosecution, that is to say, to allow the said documents be tendered in evidence. Now they filed an application at the Supreme Court to prohibit the judge from hearing the case further, raising issues of bias. Now, having filed that application, they come before the High Court judge again to say that, look, we have a pending application at the Supreme Court, and as such, kindly grant us an adjournment so that the Supreme Court will deal with that application, because it will have implications on whatever we're going to do here.
Right.
Then that was also opposed by prosecution, because prosecution's position was that the mere filing of an application does not operate as a stay of proceedings, or it does not automatically make the court to adjourn the matter.
Right.
So they were minded to proceed with the case. But defense was not pleased with the position, with that. I mean, eventually the court had to make a determination as to whether to adjourn the proceedings or even to stay the proceedings.
Indeed.
The court took the view that the proceedings must continue.
Right.
What it meant is that the defense argument had fallen flat, so they had to proceed. And that was when defense did not agree with that position taken, to mean that they have an application pending and that their pleasure would have been that the court would allow them to proceed with the matter.
Right.
It was in the midst of that that the attaché, together with the lawyers who came, sought leave of the courts in the midst of the circumstances. So the accused person was asked to call his lawyer to come, because, I mean, he was there for the accused person. According to him, he made attempts to reach to his lawyer, but by the time he got the lawyer was already gone. But that was an interview that he granted to the press to express his frustration or the situation that he found himself, for which he acted the way he did. So, I mean, basically, that was what happened in court. And this will be the third time we are seeing some sort of drama in there. First time being his own client openly disengaging his services in open courts.
Yes.
The next time that client switch rules, that's mean move from an accused person to being a prosecution witness. And today we are now seeing that in the middle of proceedings, the lawyers walk out of the courtroom. That's just by way of update of what is going on in this particular trial involving the former Director General of the National Signals Bureau.
It's one that we'll keep an eye on. Dennis, appreciate you for this.